Welcome to another edition of Kennebec Valley Forum. This is the second in a series on elder law with attorney John Nail. Welcome again, John. And today we're going to talk about advanced directives. What are they?
Well, thank you for having me again. And advanced directives are the legal documents that a person would put in place giving direction or transferring authority to another person regarding certain matters. And there are a number of different types of advanced directives. The first and probably most common and definitely most needed is the healthcare advance directive.
Okay. Give me a little background on that, John, if you would. What it is for health care, what is advanced directive, and that. Clear it up a little bit for me. I'm a little bit confused.
Okay, so a healthcare advance directive is the legal document that says that in the event a person cannot, on their own, communicate with their doctors, make healthcare decisions on their own, decide where they're going to receive the health care, who's going to provide it, and even when they want their health care to end, then they put it in writing and they give that authority to another person. And it says basically that when I cannot make my own health care decisions, when my doctor decides that I cannot make my own health care decisions, then I direct that this person have the legal authority to step into my shoes, talk with my doctors, make my health care decisions for me. And in the health care directive that we prepare, we like to have a primary agent, and if the primary agent can't act for any reason, either maybe being out of state or just not being able to act for any reason, then we like to have a backup person. We like to give the document some depth.
Right, that would make a lot of sense.
And then also within our healthcare directive, we give the agent the authority to make end-of-life decisions for the person as well. And that is sometimes done through a living will, which is a separate document. But in our office, we like to combine them into one document. And of course, when you appoint somebody through the healthcare advance directive, you're appointing a loved one, a trusted member of the family, your spouse, your child, or a friend, to make these healthcare decisions. And it's important not just to sign the document, but it's important to have the discussion with your agents as to how you feel about your health care and how you feel about the end-of-life decision that somebody might have to make for you. And regarding that end-of-life decision, you're telling that person that, look, in the event I am in a permanent vegetative state, my quality of life is so low that at that point in time, I want you to tell my doctors hands off. I want you then to tell my doctors that I want to live naturally and die naturally. Or you're going to maybe tell that agent that, look, I want to be kept alive by all means, no matter what. And when my maker wants me to go, he'll take me. But otherwise, I want to be kept alive on machine or medications or whatever might be available. So that's an advance directive that we all ought to have in place, regardless of our age.
Right.
The second advance directive that we all ought to have in place is the durable power of attorney.
Okay.
Advance directive.
What does that cover for?
The durable power of attorney covers, in the durable power of attorney, we're appointing a trusted family member, loved one, friend, to step into our shoes when we cannot make our own personal, legal, and financial decisions. And what that document says is look, in the event I can't, make my legal, personal, and financial decisions, then I want this person to have the legal authority to step into my shoes and carry out, and have the legal authority to carry out decisions and make decisions and carry out decisions regarding my personal, legal, and financial affairs. There are a couple of different types of durable financial powers of attorney. First of all, we call them durable because we want them to continue to be effective even should we lose our mental competence. That's the durable part. And of course, as elder law attorneys, that's the type of a document that we want to be in place. We
Sure.
want it to be durable.
Sure.
We want it to be effective in the event the client is no longer able to. If it's not durable, then when the client becomes incapable, then the document is going to end. We want it to be durable. And, excuse me, you can have it be effective immediately, and that's the way we draft them, because when you give the authority to a trusted family member, loved one, or friend, then that person knows not to use it immediately and only to use it for your best interest. The other type of a durable power of attorney is what we call a springing power of attorney. It is not effective when signed. It is only effective when your doctor declares you to be incompetent.
Okay.
That involves another layer of review that has to be done by a doctor, and in making the decision that you are incompetent. That's a little more difficult for the family to deal with, especially in the situation where maybe mom and dad are not incompetent, they just need a little bit of help with their finances, or with their insurance issues, or tax issues, so they're not really incompetent. So you wouldn't get a doctor maybe to say that mom or dad is
Right.
incompetent. So we do the durable power of attorney, and it takes effect immediately, but because the trusted family member knows not to use it immediately.
Right. I know there's several that powers of attorney, I know enough about it to be dangerous, is some stop at when they pass away. Some continue on. There's several different, I believe, powers of attorneys that may exist.
Well, all right. Let's see. They all end when the person passes.
Okay.
However, they can be revoked at any time.
Okay.
You can appoint somebody today and then maybe think that maybe another person is a better choice, and then you can revoke the earlier power of attorney and execute a new power of attorney, appointing another person or other people. But they all end when we end.
Yeah, okay.
And in Maine, we just passed a new Durable Power of Attorney Act a couple of years ago, and basically what it says is that if you don't have the authority specifically set forth in the document, then you don't have the authority.
Wow.
So in the Durable Power of Attorney document, we as elder law attorneys, we put in the basic authorities for somebody to help with personal, legal, and financial affairs.
Sure.
But we also include some certain specific authorities that go beyond those basic authorities, so that the agent can help the elder in the way that an elder needs to be helped. For example, we have in our document, our power of attorney document, that the agent has the authority to do what is necessary to apply for any government benefits that the senior may be entitled to, and to take all action appropriate so that the senior can qualify for the government benefit, such as a veteran's benefit or a main care benefit.
Okay.
And then we also give the agent the authority to engage in a proper asset preservation plan so that the elder perhaps can qualify for the government benefits sooner rather than later.
Sure.
And the sooner part is that the government benefit is going to take place sooner, and assets perhaps have been preserved, whereas later means that probably all of the assets have been expended, no assets left to be preserved for the benefit of the family. So we like to put that authority in the document.
As these directives are put forth, John, we have entities that come in, like the state of Maine, for instance. If they give you care within your home, they take a lien on the home to assure their money being paid. You have to interact with that as well in your planning process, and so do the people there. And it gets kind of complicated sometimes with all these things that the veterans are in, the state is in, and all these things that come in to make the whole pie, so to speak. So they need your help to guide them through that maze and make sure that they're protected and taken care of.
So the only time the state would get involved would be if a person does apply for the main care benefit. And that main care benefit is the benefit that would help pay for at-home care, assisted living care, or nursing home care. And when a person applies for that government benefit, he or she has to do a full disclosure of their assets at that time and what they did with their assets during the last 5 years. Because the state of Maine wants to know if, in getting down to the allowable asset limit, they want to know what you did with your assets during the last 5 years to get down to the allowable limits. And if a person made transfers of assets, gifts of assets within the last 5 years, then the amount of those gifts is going to be determined by the Department of Health and Human Services, and based on the amount of the gifts, there's going to be a period of ineligibility applied to your application. So that, just for example, if a person during the 5-year period immediately preceding the application for the main care benefit gifted $100,000 to a child,
Yes.
and then applies for the government benefit, the state is going to say, no, you gifted $100,000 to the child within 5 years, now you have to pay the first $100,000 before we'll get involved.
Okay.
So you want to do proper planning.
That's why they need to come to you
Right.
before
That would
they
be one
even,
reason.
the earlier the better, I would think, John,
Exactly,
to
the
come
earlier
to
the
you.
better. The earlier the better, because the earlier they have more options. If they come to us early enough, then, and if their health is good enough, then perhaps we engage in a 5-year planning process. But if we're talking to somebody a family whose a parent needs care now, then we don't have that 5-year planning process. We have to go into a crisis planning situation. You can still preserve assets, but not as much as
Right.
perhaps if you had planned earlier.
Right, and I think looking at the directives that you have here, sometimes children get into a situation with their parents that they see their parents from a different perspective. Some parents think they can drive forever,
Right.
They think they can do a lot of things forever.
Right.
And the children say, but you can't. And they come to you, how does that work out with the parents if they are on the other side of the fence, so to speak?
So you raise a good question, and it's one that a lot of our clients struggle with. Elders, parents, any of us. Today it's our parents, tomorrow it's us.
Yes.
We don't like to give up our independence. We want to continue to drive. We want to continue to maintain our finances. We want to continue to live at home. And because the aging process is a process, it doesn't happen all at once. We very often have to work with families, children, regarding keeping their parents safe,
Yes.
maybe not driving, keeping them at home, but having somebody come in because they can't do their own cooking anymore, but yet we want to keep them at home for as long as possible.
That's right.
So it's a balancing act, and it can be a struggle in the family. And oftentimes we get involved in those situations, just trying to help the kids understand that mom and dad don't want to give up their independence, and
Right.
maybe helping mom and dad understand that for their own safety and for the safety of others, they have to kind of limit their driving or other activities at home, or maybe have a caregiver come in, maybe leave the home.
Sure. You know, depends on what they're doing and what harmful effects it has.
Exactly.
I'm sure.
So how do we keep them safe?
So I would suggest, and maybe it's a thought of my own and has no relevance to anything, that children that are looking at situations like that, saying, well, mom and dad are failing a little bit, but they're doing okay. I can bring them over some food once a week, or we can do some stuff to get them through. I would think that that's the time for them to come to look at elder care, talking with you,
Yes.
saying, why do we go from here? How do we, down the road, we got to do some planning here.
Yes, yes.
Get some directives in place to do that.
We like to see the whole family be involved. We like to have it be a family affair so that everybody knows what the parents' needs are, can help to meet those needs, can help the parents with their advance directives, getting the healthcare advance directive in place, getting the durable power of attorney document in place. If a person doesn't have the healthcare power of attorney in place and now is not competent to sign a healthcare power of attorney in place, then the family has to petition the probate court to have a guardian appointed. A guardian has control over the person, where that person is going to live, what type of health care they're going to receive, where they're going to receive it. If the senior doesn't have the durable power of attorney in place and now is not competent to execute a durable power of attorney, then the family has to file a petition in probate court to have a conservator appointed. Conservator has control over the person's assets. The guardian, control over the person, the physical body of the person. Conservator, control over the assets of the person. So as you can imagine, it's
Well,
much
it's
easier.
a nightmare.
Yeah, if you filed a petition in probate court, there's going to be an attorney involved for the family member who files the petition. And then because we don't take away a person's rights too easily in this country, the court is going to want to make sure that the senior, the incapacitated person, has a lawyer as well. And then to make a determination as to the competence or incompetence of the person, we're going to have a doctor get involved. And then to make sure that the environment of the senior and the person who's going to provide the help, to make sure that that's a good fit, then we're going to have a home visitor. The court is going to appoint a home visitor.
Boy, the cost is escalating quickly.
Exactly. Whereas if you do it in advance, if you're proactive, then you just simply come into the office with mom and dad, we talk about it, prepare the document, sign the document, and it's done.
Yeah,
Otherwise,
very simple.
it's thousands of dollars,
Yeah.
and it's months later, and it's court appearances in
Yeah,
order to
and-
be appointed guardian and conservator. So being proactive.
And then when you get different factions that are looking to gain their own balance on their own side of it, it becomes,
You can have that
you can
as
fracture the family very quickly
You
in
can
probate
have
court.
that as, right, you can have that as well. And of course, by trying to make it a family affair, one of the biggest goals of all of us is to have a good family with children helping
Right,
the parents and all working together. The other types of advance directives the healthcare power of attorney and the durable power of attorney, those advance directives are put in place for others to help us while we are still alive,
Right.
but can't carry out our own decision-making regarding healthcare matters and financial matters. The other types of advance directives that we ought to have in place take effect perhaps when we pass. And those advance directives deal with what's going to happen with our estate.
Okay.
And those advance directives can take the form of course, what we're mostly all familiar with is a simple last will and testament.
Right.
On my death, I direct that this person now have the legal authority to step into my shoes as personal representative, gather my assets, pay my bills. Then I direct that person with the balance of my estate, I direct that person to distribute it as follows.
Right.
To my children, to charities, to friends, to my spouse, whatever a person's wishes might be. That's a type of an advance directive regarding the distribution of assets. Other forms of advance directives that can become effective when we pass regarding the distribution of our assets could be a trust. Person puts his or her assets into a certain type of a trust while they are alive, and then directing that when I pass, I want this person to step in as the new trustee, and I want the assets that are in trust to be distributed immediately, or I want the assets in trust to continue to be held in trust, and I want my trustee to make periodic distributions. Or if you're providing for a disabled child or individual, then you're going to want the assets held in a certain type of a trust for the benefit of that individual, so that if that disabled individual is receiving government benefits, he or she will not lose the government benefits because of an inheritance.
Right.
And the idea there is to put the inherited funds in what we call a supplemental needs trust, so that the disabled individual who's receiving government benefits can have the benefit of the government benefits and then have the benefits of the assets that are in the supplemental needs trust. According to federal law, you can continue to maintain your basic government benefits and have your inheritance in a supplemental needs trust, and the funds in the supplemental needs trust do, as the name states, it supplements the government benefits. Other advance directives that come into play after we pass, again for the distribution of our assets, are as simple as the advance directive that somebody gives a life insurance company that says, on my death, I want you to pay the life insurance benefits. I want you to pay them to my spouse, my children. Another type of advance directive can be just simply adding a payable on death designation on a bank account or on a stock portfolio. And then what you're doing there is you are directing the bank in advance of your death, advance directive, you are directing the bank that on my death, I want this account to go to my spouse or to my children. A payable on death designation is different than adding somebody's name as a co-owner
Really?
to a savings account.
Okay.
Because when you add somebody's name as a co-owner, they can go to the bank that day and withdraw the funds. We frown on that as elder law attorneys. Whereas the payable on death designation, you continue to be the sole owner of that account, and only on your death do either your spouse or your children then and only then do they have access to the account.
Right.
And it can be divided, again, according to the terms or the wishes of your estate plan. You can have a savings account, a CD, and you can direct the bank in advance
Yeah.
through the payable on death designation to divide this account equally between my 1, 2, or 3 children. You can, so these advance directives, depending on the situation, they can be used, one can be used to carry out your estate plan,
Okay.
or a combination of them can be used to carry out
So
a
you could have a
person's estate
bundle,
plan.
you could have a
Right.
bundle of directives, so to speak, and cover everything that you need,
Yes.
or just one, depending on what your needs are.
What we try to do with our clients is that, you know, to the extent that it's possible, we try to help them avoid the probate process.
That's an expensive process.
That's an expensive process, and it's a lengthy process.
Yes, it is.
And it requires a lot of involvement from family members to become involved with the probate court and file petitions and file accountings and different things like that. Whereas if, and the last, if you're going to use the last will and testament as your advance directive for the distribution of your assets, then that process is a probate court process.
Oh, yes.
Whereas if you're using the trust as your advance directive for the distribution of your assets when you pass, that is not a probate court process. If the trustee, and it can be a family
Sure.
member, just simply steps in on somebody's passing
Right.
and then makes a distribution of assets according to the terms of the trust. No probate court. The advance directive that you gave the life insurance company, no probate court. Just simply submit a death certificate and they'll make the payment. The advance directive that you give the bank or your stock portfolio company, or maybe on your retirement accounts, listing somebody as a beneficiary, again, no probate process. Just simply present a death certificate and the bank will either change the name on the account or make a distribution or roll the IRA over. Again, no need for the probate process there either.
One of the things that I've seen in my workings is the irrevocable land trust that people have, that they put on the houses, elder people.
Okay.
And set it up as a trust. Now, that's an option as well as a directive.
Yes. Quite often, family members will want to preserve a piece of property, real estate, either a farm, a woodland, a cottage, a camp, and they want to make sure that that property stays in the hands of their family. And of course, we as elder law attorneys, and me being a Mainer myself, I encourage that, we encourage that, and we want to make sure that happens. We want to keep as much of the shoreland property in the hands of our children as long as possible, because a lot of it is being purchased by people from away.
Right.
So what we help them do there is we help them set up a real estate family trust. And you're right, it's irrevocable. So the asset, the home, the farm, the camp, is transferred into that irrevocable trust. The trust now owns it. The parents can continue to use it. The parents can continue to make payments on it, can pay the taxes, the insurance, and then within that document, we set up a framework of how it's going to be used by the children, by the grandchildren, what their responsibilities are, what their use rights are, what happens if there's a disagreement, what happens when the grandchildren and great-grandchildren now are maybe not living in the area and now it needs to be sold, how it's sold and how the proceeds are distributed. And that's a very useful tool to keep the property in the home and to provide a management and use arrangement for the family members.
That's good. So they should be talking to you soon.
Yes, about that.
and,
Or
or
any
the
of
other
it.
directives that come to mind, and as you illustrated today, that the sooner we get on board, the sooner we can do that estate planning or planning for life that you need to do.
And the advance directives for, to be used while we are alive are very important. The healthcare power of attorney, the durable power of attorney, and of course, the advance directive for the distribution of our assets when we pass, all very important.
Absolutely. Thank you, John. I appreciate that. And that's another edition of Kennebec Valley Forum. We'll see you next time.